Hello students, uh, welcome to the online classes of LLM CBSC course, semester LLM part 2, semester 3. I'll be dealing with intellectual property rights, all chapters, all papers. Dr. Chandrani Bagri madam will be dealing with some of the topics of business law group, and Saurishila Patil will be, Swati Hazare, madams. They will be dealing with the skill enhancement course and some of the business law group subjects. So today, I'm going to begin with the timetable of your LLM class. So let us see the timetable first. So this is your timetable. We have already finished the first and second sem. We'll be venturing into semester 3 now. Now I'll be showing you both the syllabus of IPR as well as business law. This is business law semester 3 syllabus. We are having 5 subjects. The first one is banking law, which is for 100 marks, 80-20 pattern, which consists of 4 credits. Then insurance law, again the same pattern. Then law relating to consumer protection and competition. Then international trade laws, and the skill enhancement course, which is called as right to information laws. So this is for the group number 1, that is business law. So let us see the syllabus of semester 3 of intellectual property rights. The first paper is on law of copyrights. Second paper deals with law of designs and integrated circuits. Third paper deals with geographical indication and confidential information. This second topic or second subject is law of intellectual property and biodiversity. Then we have law of intellectual property and information technology. And finally, we are going to learn skill enhancement course, which is called as right to information laws. Okay, so these are the topics that we are going to cover under this particular semester 3. Right now, friends, let us come to the next screen sharing. That is, I'm going to share with you the first. So since we are going to deal with intellectual property rights first. So this video is basically for group number 2, and we are going to deal with the subject called as the first paper, that is called as law of copyrights. So I'll be posting these kind of videos on your on my YouTube channel, and I'll be sharing this the link of this video to you on WhatsApp. So kindly, based on your groups, kindly go through the link and go through the presentation, and then after the presentation is over, you can have you can ask me any questions based on the topic, and then those questions can be posted on WhatsApp group, and I will try to answer those questions. Okay, so this is not a live session. Please remember, study well. All the best to you. So let's start. My first topic is law of copyrights. So let us begin with this particular topic. Now, what do you mean by copyright? Let us go to the historical definition or historical origin of the word copyright. Now, the copyright has been derived from the word called as a copy, the phrase called as copier of words. This is according to the Oxford Dictionary in the year 1958. The word copy dates back to 1485 AD, which connotes a manuscript or printing material. Now, if you can see the Black's Law Dictionary, it defines copy as transcript, imitation, that means duplication, reproduction, creation of copies of the original writing. It may also include painting, instrument, etc. So this is called as copyright. Let's go to the next slide. Now, how this Copyright Act came into existence in India. Now we know that we have been ruled by British in the past. So in India, it was during the East India Company, when the East India Company arrived in India to trade with us, they passed the first Copyright Act, which was introduced in the year 1847. So that was the first act in India. Again, in the year 1911, a Copyright Act was passed in England with some more improvements, based on which, again, British were ruling in India. So they, based on this particular act of 1911, British India passed a Copyright Act in the year 1914. So that was the first act after the East India Company passed that particular act. So after 1911, we had the first act passed by the British government in India, which was in 1914. Now, what is the position after independence? Soon after the independence, Indian government passed the Copyright Act in the year 1957. Subsequently, this act was amended many times due to the influence of many international treaties for which India was a signatory. The treaties which has influenced the change in the above is the Berne Convention 1886, the Universal Copyright Convention 1940, the WIPO, that is World Intellectual Property Organization Copyright Treaty, etc. So these treaties made or influenced the passing of a comprehensive act in India in the year 1957. Let us move ahead. Now, this is, I have a picture downloaded from the Google, which shows how exactly the painting or the printing or copying used to get carried out during the ancient period. Now, what is copyright? Now, you must have already seen on a particular book inside the inner page of the book, any book. Suppose if you open that particular book, or if you can see any written work, you can see a symbol C written in a circle. What is the meaning of that? It means that the copyright, all the copyrights in that particular work has been reserved. Reserved in the sense, the author of this particular matter is the owner of this particular work. Now, what is copyright? It is the exclusive right given by law for a certain term of years to an author, composer, etc., or his assignee to print, publish, and sell copies of his original work. Now, let us come to the statutory definition of copyright. Section 14 of Copyright Act 1957 defines copyright as: copyright means an exclusive right to do or authorize others to do certain acts such as literary, dramatic, or musical work, artistic work, cinematograph, film, and sound recording. These are the subject matters of copyright. That means what can be copyrighted, what can be protected under the copyright. So it is a literary work. Now, what do you mean by literary work? Literary work in the sense that is the work which is written or printed, or any sculpture, or any carving, or in anything which can be converted into a particular document. Documentary work is called as literary work. Then dramatic. Dramatic means drama. The person who writes a drama, that script of drama, manuscript is called as literary work, or which can be protected under Copyright Act. Or musical work, the person who writes the musical notes, that work is called can be uh, can be protected under the Copyright Act 1957. Then comes the artistic work. Artistic work includes your painting, your architectural work, anything which consists of uh, skill and labor of the true owner. Then comes cinematographic film. Now, films, all the rights from a particular film are vested in one person who is responsible for the creation of that particular movie. That person is called as the producer. Sometimes the producer and director is same. So whoever invests money in that particular film is the owner of the film. And lastly, we come to the sound recording. Now, what is sound recording? Sound recording means that, for example, we have a company called as uh, uh, MTV, then T Series, then HMV, then we have Sony. We have so many companies which create or uh, they compose the music and then they produce music, songs, etc. All these people, they have a right, and that right is protected under Copyright Act 1957. Now, here you can see what kind of copyright, what kind of work can be protected under copyright. The first thing I have already told you, we have already mentioned about musical work. Next is the website design can also be protected under, since it is a literary work and it's a program, computer program. Then video or film, then sound recording is protected under the Copyright Act. Then literary work, that is which is written books, articles, etc. Then pictures, the person, the of professional photographer, when he clicks photographs and if he publishes, the photographs which are published are automatically protected under copyright. Then computer code or computer program is also protected under copyright. Dramatic work, choreography is also as an art, it can be protected. And then motion picture, right? So these are the copyrightable work. Then let us come to the act which is applicable for protection of copyright in India, which is called as Indian Copyright Act 1957. As we already have seen that the first right in India, copyright in India, was passed in the year 1914. Now, after the independence, Indian copyright is governed by Indian Copyright Act 1957 with effect from 1958. Now, this act has been amended so far for several times, starting from 1983, 84, 1992, 1994, 1999. Now, all these amendments took place to make some improvements in the act as per the change in the time, change in the technology, change in whatever is the, the requirement of that particular year. To comply with the latest provisions, these amendments have been carried out. This act adopted many English provisions, introduced new ideas and concepts. This act created Copyright Office and Copyright Board, in which you can file appeal. And in Copyright Office, you can claim or you can apply for protection of the copyright or registration of copyright. It also introduced civil and criminal remedies against infringement. Now, what do you mean by infringement? Somebody unauthorizedly, if anyone copies without permission of the real owner, then that act amounts to infringement of copyright. Then, as far as India is concerned, Indian perspective on copyright is divided into two forms. The Copyright Act 1957 confers copyright protection in the following two forms. Number one, economic rights, and second is moral rights. Now let us come to the first one, economic rights. Several exclusive rights typically attached to the holder of a copyright. Now, which are those rights which can be included under economic right of a true owner of a copyrightable work, copyrighted work? The first is to produce copies or reproductions of the work and to sell those copies, including typically electronic copies. Now, let us take an example. If I have written a book, now unless that book is reproduced or duplicated, I will not be able to distribute that book to anyone else, because I'll be having only one copy. So I should have, as the author of the book, I should have the right to reproduce it. So what I do, I approach the publisher of a book, I request him to publish. Now it depends on my economic capacity, how many copies I want to be printed. Now the next job of me will be to advertise that particular book. So I must see that the book gets sold so that I can earn some money out of it. So whatever labor, skill, and time and money that I have spent to write that particular book, all those things have to be protected. So a copyright is given to me so that I can use all those rights exclusively without anybody's disturbance. So that is the first right that is available to me. Next is to import or export the work. Now, whatever work I have created, I must have a right to do business with that. Okay. So if I have invented certain, if I have created a particular artistic work, I can even import from a place or any material that I require to create that particular copyrighted work. Or I can export my work to foreign countries. Next is to create derivative works, works that adapt the original work. That means I must have a right to give license to uh, for the adaptation of the work. Now, what is the meaning of adaptation? Now, I have a original work. Say, for example, I have written a book. Now, you must have. Let us take a latest example of Half Girlfriend. Now, you know the author. The author has written a book called as Half Girlfriend. Now he owns the copyright in that particular book. Now that book has been now converted into a movie, which is called as, again, the same name is given, Half Girlfriend. Okay, I think um, Bonnie Kapoor's son and Shraddha Kapoor are the cast in that particular film. Now, while let's see, the producer and the director cannot just pick up one book, a story, and start making film and make some money just like that without informing the true owner, the true author of the particular book. If he does that, that amounts to infringement of copyright of the original writer of that particular book. So what is to be done? So producer might have approached the author, and they might have paid him some royalty. Then he might have allowed the producer and the director to produce that particular film. Now, that is called as rights to create derivatives, to adapt the work, to convert the original work into some other form. That right is with the original owner. Next right is to perform or display the work publicly. So whatever is my art, whatever is my creation, I must have a right to display that work in the public. So that right is also available to me as an author. Next, to sell or assign these rights to others. Now I can, for example, if I cannot publish a particular book, since I don't have money, I can approach the publisher and sell my right to him, right to publish. Okay, so all the rights in that particular book will be with the publisher. The publisher need not ask me any permission if he wants to print more copies. But if I reserve that right to me, that means I'm not selling my right to anyone, or I'm not assigning my rights to anyone. I'm the exclusive owner of the rights. And the last right is to transmit or display by radio or video. Again, whatever is my creation, I can convert, or I can display, or I can publish it in the form of a radio or video. Let us take an example of a movie called Sholay. Now, Sholay was a super hit. The CP brothers, they are the producers and directors of that particular film. Now, that film has been also telecast on a FM radio in Kolhapur, in Pune, sorry. So I happen to be a friend of one of the RJ in that particular, or the announcer of that particular FM channel, FM radio channel. We had a discussion, and as I said that I am specialized in intellectual property rights, she said, okay. Then she says, yes, I know what is copyright, because if when we wanted to telecast the dialogues in audio form of Sholay on our FM radio channel station, we had to approach the CP brothers, and then we had to take permission from them, and then we could convert that movie into an audio form, and then we could telecast it on the radio. So these are the rights available to the uh, author. Let us come to the second perspective of copyright, that is moral rights. This has been divided into two parts: right of paternity and right of integrity. What do you mean by right of paternity? It means to claim authorship of work and to prevent all others from claiming authorship of his work. Now, the moment I write that copyright, all rights are reserved, and I use that particular symbol of C inside a circle, that means what? No one will be authorized to duplicate this particular work without my permission. That is called as right to paternity. I own the right since it is my creation. Next is right of integrity, to prevent distortion, mutilation, or other alteration of his work, or any other action in relation to said work, which would be prejudicial to his honor or reputation. So whatever work has been created by me should not be destroyed or distorted or changed, or whatever way, it should not be taken away from me without my permission. So these are the two rights which are provided to the copyright owner under Indian Copyright Act. Now, what is the term? For how many years this right can be claimed by the owner? The term of the copyright. The general rule is that copyright lasts for 60 years if it is counted in two ways. It depends on what kind of work it is. So from the death of the author, if it is a literary work, or for example, a book. If I write a book now, my rights are protected till I'm alive in that particular book. After my death, for 60 years, for 60 years, nobody will be allowed to copy my book and claim it as his work or her work. If it is a literary work, then dramatic work is the same till the life of the writer, and after his death for 60 years. Then musical work, artistic work, etc. Let us come to the next category, from the date of publication. In case of cinematograph film, if a film is published this year, that is 2020, the period of protection will be available to that particular film for 60 years. For 60 years, nobody will be allowed to duplicate my film without my permission. Sound recording, then photograph, posthumous publication. What is the meaning of posthumous publication? A publication which takes place after the death of a particular person. Now, let us take an example, latest example of Sushant Singh Rajput. His Dil Bechara movie has been uh, released after his death. That release is called as posthumous publication. Works of government and international organizations. So all these categories comes under the 60-year period after the publication. Okay, not for the life as it has been provided in the previous case. Registration of copyright. Now the question is whether registration of copyright is necessary or essential. Now, suppose if for a work, Berne Convention is applicable, there is no registration needed. Then acquisition of copyright is automatic with the creation of a work. The moment I create a book, see, I did not mention in my book copyright symbol and all rights are reserved and not. I did not do that. I did not even register my copyright. The moment I publish that particular book or a creation, automatically my rights are made available to me and my work is protected under the Indian Copyright Act. But it is not that you should not always register. Registration is a prima facie evidence of my copyright existing in that particular work. Now, if there is a case, court case, and if I have to prove that that work belongs to me, suppose I have a registration document of my copyright, that will be a prima facie evidence that work belongs to me. Now, how to use a symbol? What is that symbol represents? Use of that copyright symbol. Anyone who claims copyrights can use it on his work. It is not necessary to have a registration to use the designation. I can even use a C symbol on my work which may not be registered. As I have already told you, I need not register my work. Highly advisable. It is highly advisable to incorporate a copyright notice. For example, suppose I have a book, I have to mention copyright with that particular symbol, the year of publication, and who publishes it, or the name of the company. If I give this particular notice, it is a signal to a person who is trying to steal your work. So nobody will be able to steal my work without my permission if I use this particular copyright notice. Now, what do you mean by counterfeiting to copyright? Counterfeit mark, the production of certain brand name bags by putting a false label and sold at low price. Now, you can see in the market, many things are being sold with the original label of a particular company. The product is duplicate, but the label will be original label. This is called as counterfeit mark. So it's violation of copyright. Then counterfeit products, copies of articles similar to the original under a different name. Some of the cheating businessmen, they do this. They use similar kind of goods, products. Best example is the Las Nagar, where you can find all types of products just like original, but their guarantee is only for 2 to 3 months or 6 months. After that, we have to just use it and throw. Then infringement mixed. Now there can be copy for both the model and the brand. Example, fake Louis Vuitton bags or Rolex watches, for instance. Now there can be a mixed duplication of a particular product. Then infringement of copyright. Copying or using the work of another creator without his prior permission. Now these are the types of copying and duplicating others' work. Acts resulting infringement. Now, what do you mean by infringement of copyright? Making infringing copies for sale or hire. Now, for example, if I go to a particular place, I buy an original book. Now, that book is very, very rare. For example, it cannot be found easily in the market. What I do, I Xerox it, remove the first page, and put my own name and everything, all duplicate. And then I sell it by saying that that is my original work. This is called as infringement of copyright. Then permitting any place where performance constitutes infringement of copyright. Now, if a person who owns a particular place, who knows that some kind of duplication or some kind of crime against copyright ownership is going to be conducted in a particular place which I own, if I have a knowledge, then I'll be the culprit. I'll be the accomplice, or I will be the supporter of that particular crime. Distributing infringing copies for the purpose of trade. Now, if I distribute the products in the market, which I know that they have duplicate, then I'm the accused. Then public exhibition of infringing copies by way of trade and importation of infringing copies. Now, in the past, there used to be duplication of films in foreign countries, and those goods used to be imported back to India and sold here. Or I know that these goods are duplicate. Even after that, I'm displaying it in the street and selling them. If I do that, I'm the infringing person. Now let us see what are the remedies available for infringement of copyright to the owner. There are three kinds of remedies: civil, criminal, and administrative remedies. Let us see one by one. Under civil remedies, we have injunction, damages, accounts of profit, delivery of infringing copy, and damages for conversion. Injunction in the sense, I can convince the court that I have a prima facie case that the person who is dealing with the duplicate goods which belong to me, he's creating infringement against me, and I'm suffering loss. So he has to be stopped immediately. So I can claim injunction in the court. So injunction will be issued, and then that work will be stopped. Then damages, whatever damages I suffered, the court has to direct the accused person to pay me the damages which I suffered. Then accounts of profit, whatever accounts of profit he has earned out of my name or fame or creation, that has to be accounted for and paid back to me. Delivery of infringing copy. So whatever copies he has created with the help of duplicate machinery and all those things, and all those have to be handed over to me as I'm the true owner, so that nobody else can again duplicate the same thing. And lastly, damages for conversion. Suppose that person might have converted that work into a movie without my knowledge. Then whatever damages I have suffered because of that, he has to pay me back. Now, where to file this particular case? I have to file this civil remedy, case for civil remedies, before not below than district court. Let us come to the next type of remedies, which are called as criminal remedies. Criminal offenses if done knowingly. Now, what is the meaning of this? Suppose I know that the goods which I'm dealing with are duplicate goods and have been created without the permission of the true owner. And if I engage myself in that particular trade, then that act is called as criminal act, and I will be punished with imprisonment starting from 6 months to 3 years, and with a fine of 50,000 up to 2 lakh rupees. And my whatever infringing copies are there will be seized. Limitations of copyright. Idea or expression. See, copyright protects only the original expression of the ideas and not the ideas themselves. For example, if I tell a story to a particular director or producer, and that director or producer creates a film or produces a film, now the copyright will be available with the producer and not with me, as I only had ideas. The first sane doctrine. Copyright does not restrict the owner of a copy from reselling legitimately obtained copies of copyrighted works. For example, if I bought a book, original book on Constitution of India by J.N. Pandey, for example, I can sell it as a secondary copy to some other person. Now, for this, the author cannot object by saying that no, you cannot sell that particular book. It is my creation. See, the moment I buy that particular book, I am the rightful owner of that particular book. But I'm not the owner of the copyrights. But I'm the owner of that product. I can resell it. If I duplicate those things and then sell, then I'll be committing infringement of copyright. Limitations to copyright again. Deals with fair use and fair dealing. Now, there are some certain exceptions. That means for the purpose of research or private study, if I use somebody else's work, then I have to acknowledge that I have taken that work from someone. This is called as uh, acknowledgement and fair dealing. If I don't do that, then I'll be committing plagiarism. Plagiarism is nothing but using somebody else's work without mentioning the source. Next, for learning and teaching in a classroom, suppose I'm using to teach you if I'm using somebody else's work without his permission. See, I'm not commercially exploiting it, but I'm teaching it in the classroom. So I'm not committing any kind of crime. For criticism or overview, now, for example, if somebody uses in a news channel somebody's work and then he fairly criticizes or analyzes, that is not a infringement of copyright. For reporting current events, again in the news item, in connection with judicial proceedings. Now, for example, in judicial proceedings, if judiciary uses or the advocates they use somebody else's work, then that does not amount to violation of copyright. Performance to non-paying audience. For example, if I perform something on a charity base in the public without the permission of a true owner, it does not amount to infringement of copyright. Other specific conditions also gets applied. Again, under limitation to copyright, we have that means copyright cannot be claimed in this work also. Some government works are exempted in India. Act of legislature. If the act of the legislature is copied by somebody, it does not amount to copyright violation. Report of a committee, commission, council, board, or other like body appointed by the law. If it is used in a particular research work or any other work, it doesn't amount to violation of copyright. Judgment or order of a court, tribunal, or other judicial authority. There is no copyright on any one of these books, creations of government. Now, amendments to the Act. India being a member of the Berne Convention and Universal Copyright Convention of the international, at international level, amended its Copyright Act in 1957, of 1957 in 1983, 84, 92, and 99 to bring the Indian law, that is copyright law, in conformity with these international conventions. Copyright is protection in the form and not in the idea. This has been already discussed, but yet we will deal with one of the case here. Jeffries versus Boosie. It is based on the right of an author, artist, or composer to prevent another person from copying his original work, when it is a book, tune, or a picture. Okay. So if a creation, if a work has been converted into a material form, copyright is available only in that particular material form and not in ideas alone. So thank you. So that's all. We have introduced the topic copyright in this particular lecture. Thank you for your patient hearing and see you in the next class. Thank you so much and take care.